This is the time and place set for the case of Arnold versus Kotek. Justice Massey is not participating, but we have Judge Tukey participating pro tem. And we'll start with counsel for petitioner.
Good morning, Honorable Justices of the Oregon Supreme Court. Counsel, may it please the court. My name is Tony Aiello Jr., and I represent plaintiff petitioners on review in this matter. The opinion makes two serious errors I want to address right at the start. The first is that it goes to plaintiff's third question. The opinion holds that Article 1, Section 27 protects, quote, the right to armed self-defense, end quote, or, quote, the right of armed defense of person or property, end quote. The plain text of Article 1, Section 27 protects the right to bear arms for self-defense and defense of the state. All case law recognizes the right as characterized in our briefs. No case characterizes it as described by the opinion or by defendants. The right to self-defense, including lethal self-defense, comes from common law and later statute, and you can see that in the Goodall versus State case from 1861.
And how do you see that difference in phrasing affecting the Court of Appeals decision?
Yeah, so the Court of Appeals decision essentially said, well, there's alternatives to these arms. You have alternative arms available for you, therefore it doesn't violate the right to armed self-defense. There's also a portion of the opinion where the court italicizes the word defense, somewhat implying that the arms regulated by ballot measure 114 are offensive weapons. Now, the State versus Delgado case ended that argument in 1984 and said that weapons can be used defensively and offensively, and that does not change the character of them. The second major error that was made goes to plaintiff's first question. The opinion disregards the consistent approach prescribed by this court to search history for the scope of permissible legislation that can be enacted in the face of Article 1, Section 27. This review yielded the manner of use and manner of possession restrictions and prohibitions on certain dangerous criminals, namely felons. No other constitutional restriction has been recognized or by case law or even urged by defendants in this case. Measure 114 is similar to none of those restrictions. Correcting these two fundamental errors would require a different outcome from that reached in the Court of Appeals.
So can I ask you a question about the test? Because the Court of Appeals applied a test that looks like this court adopted in Christian, said, we've consistently acknowledged the legislature's authority to enact reasonable regulations. You take issue with the reasonable analysis.
Yes, Your Honor. So no case before Christian used the word reasonable.
Okay, so do we have to overrule Christian in order to adopt your view?
No, Christian, so the quote of the word reasonable comes after, if I remember right, a 3-page explanation of the manner of use, manner of possession, which comes from Kessler, Blocker, and Delgado, and the certain dangerous persons, namely felons, that comes from State v. Hirsch-Friend. It summarizes those. At the end of it, it says, we have consistently acknowledged that the state may enact reasonable regulations. It's summarizing itself.
And then the rest of the test, as I read it, it says, to promote public safety as long as the enactment does not unduly frustrate the individual right to bear arms that's protected by the Constitution.
Exactly, Your Honor.
So it's an unduly frustrate
Yes, Your Honor.
test. And that's, so you're okay with that part of the test, the unduly frustrate. You're just saying that this law doesn't, it frustrates unduly the
Yes,
right to bear
but
arms.
back to the first part is there's only certain types of laws that are constitutionally permissible under this court's case law. We have Kessler, Blocker, Delgado that say manner of use and manner of possession, absolute proscriptions on protected arms are per se unconstitutional. Then years later, we have State v. Hirsch-Friend. In Hirsch-Friend, they do an even more in-depth analysis of history than was done in Kessler, Blocker, and Delgado. And that case underscored Kessler, Blocker, Delgado and said, yes, manner of use, manner of possession, those are okay. The holding of the case pertained to felons.
So, counsel, the Court of Appeals opinion concluded that this is a manner of use regulation. They basically reasoned that the law doesn't prohibit any particular firearm. It just prohibits the use of the weapon in a way that would enable firing more than 10 shots without reloading. Why was the Court of Appeals wrong to see this as a manner of use regulation?
Well, I would start by saying I don't think they did. I think with respect to the Court of Appeals below, kind of ham-fistedly included the quote in there, but there was no analysis saying that owning, possessing, selling, distributing, importing so defined large capacity magazines regulates the manner of possession or use. What they said is it regulates the magazines that can be used to make the firearm operable. But it also contradicts itself earlier where it said, we're not going to parse out a firearm from its parts. So when we look at Kessler, Blocker, and Delgado, the language of the statute, and it was the same statute, but it had changed slightly between 1980 Kessler and 1984 Delgado, the language is almost identical. It prohibits the same conduct having to do with billies and switchblades, but then when we get over to ballot measure 114, it prohibits so defined large capacity magazines. But the conduct prohibited is not simply using it or possessing it in a concealed manner or in a loaded manner. One can be arrested under ballot measure 114 for purchasing a magazine, never putting a round of ammunition in it, and walking down the street.
So you've argued that our cases draw a distinction between entirely prohibiting a category of weapon. How would you define the category of weapon here?
The weapon here is a so defined large capacity magazine, a magazine capable of holding more than 10 rounds now or in the future. A magazine is a part of a firearm. That's really clear.
So that's how you would define weapon, as any part of a firearm?
A firearm, a knife, a club, or any part
I guess what I'm,
thereof.
and I admit factually perhaps just being not very experienced, but you can't take a magazine and do anything with it alone, right?
No, nor can you with a barrel, a trigger, a
Right.
scope, a stock. All those parts together comprise the firearm. One might think of the magazine as the engine of a car. It's the thing that makes the car go. That's an indispensable part of the vehicle. We're not talking about tinted windows or a more accessory type part.
Counsel, can I'll be very transparent with you here, right? I'm going to have lots of questions for your colleague about permit to purchase. My questions for you are really about magazine capacity, and so you've already touched on that, so I'd like to ask you a few. In your view, would Article 1, Section 27 prohibit a state mandate that all firearms sold in the state must contain a safety mechanism?
Yes, to the extent that it bans those that do not. Now, maybe there are some restrictions that could be placed on manufacturers within the state. I don't know that that would implicate Article 1, Section 27, but to the extent it bans the mere possession or mere use of an arm, that would run afoul of Article 1, Section 27.
Okay. Let me give you another hypothetical then. Let's say there was, I don't know, there was some weapon that was just wildly popular, without question the bestseller, everyone loved it. But it was determined that it was made from a particular polymer that was cancerous, right? Everyone now recognize this. Could the state ban the sale of, would it offend Article 1, Section 27 for the state to ban the sale of weapons made from this type of component, this type of material because of its cancer-causing properties?
That's a more difficult question, but I would still say yes, because you are banning the mere possession or mere use of a, I'm assuming here, a protected arm.
So your upshot is essentially there can be no product safety standards for a weapon.
Again, I'm saying more that's a more difficult question because it obviously does not have the intention of disarming Oregonians. But at the end of the day, Kessler, Blocker, and Delgado say you cannot ban, the state cannot ban mere possession or mere use. And the law you're describing would.
So back to the first hypothetical, the safeties. You agree that the state can regulate the possession and use of firearms?
Manner of possession.
Sorry, manner of possession. Why isn't the presence of a safety mechanism part of regulating the manner of possessing an arm? You can possess it as long as it has this particular feature.
Well, that would be banning, so look at the inverse of it. It would be prohibiting the arms that do not contain that. That's quite different from the manner of use, manner of possession cases that this court's
But isn't
considered.
any regulation of manner of possession also a ban on whatever violates the regulation?
But it's not on the arm, it's on the conduct. So one can carry a firearm, open carry, or concealed. So a ban on concealed carry would be a ban on a distinct manner of possessing it. It's not on the arm itself. The government cannot ban the mere possession, and the law that's being described about safety mechanisms would ban the mere possession of firearms that do not have, I'm assuming, Your Honor, speaking of an external thumb safety.
And is that because historically guns existed in 1859 without safety mechanisms, and the drafters would not have seen that as a reason?
I would say that certainly helps my argument, but at the end of the day, it's mere possession or mere use cannot be banned. Delgado uses the language, this the Constitution does not allow.
So what are the categories of weapons, of arms, that can be absolutely prohibited?
The arms that can be absolutely prohibited are those that are not protected under the test identified in Delgado. Now, that's not an issue in this case because both lower courts decided that case in plaintiff's favor, and the defendants chose not to include that as a contingent request for review. But certainly to get science fiction with it, perhaps a lightsaber may not be included within the class of protected arms. But what we're dealing with here are firearms, not unlike the firearms we had in 1859. We have a primer, we have powder, we have a projectile fired through a firearm to strike another.
Is there any limit to your rule that a characteristic of a weapon is a category of weapon? I mean, could the state ban silencers or anything like that on a gun?
That's where we would have to go back to the Delgado test. Is it the type of arm that would have been envisioned as protected by the drafters? And that Delgado test accounts for improvements in modern design and function. I would say that a silencer would be a more difficult argument to make because it is not inherent. It is not a part of the firearm necessary for the firearm to function. A magazine is.
But is a magazine of over 10 necessary for the firearm to function?
Well, so I think Your Honor's getting at the question of detachable magazines. In magazines that are a part of the firearm, you cannot take it off without deconstructing the firearm. Those are included within ballot measure 114. A detachable magazine, that's a more difficult question. We're dealing with, for instance, on a pistol, the length of the grip decides the length of the magazine. You cannot have a shorter magazine than you have a grip on the firearm. And that's not only true of pistols, but that's where it's it's easier to describe. And so there, yes, that is inherently part of the firearm. It is necessary for the firearm's function. But we're also not dealing with a question, the kind of threshold question is this part of the firearm? Even defendants experts said it was.
Are fully automatic weapons protected by the
Are what?
Are fully automatic weapons protected by our Constitution?
That case has not come before the court. I would expect that the court would hold no because they were developed solely for the military. But we don't have that history on the record. And so I'm unsure without looking at an expert witness that wasn't a part of this case.
How does the exception for things that were developed by the military tie in with your test, which just seems to be a manner or use test?
No, so the threshold question of Article 1, Section 27 is, does it apply? So Article 1, Section 27 doesn't apply to round limits for hunting. That has to do with being sporting. That's not the purpose of Article 1, Section 27. The second question is, are these protected arms? The Constitution does not apply pursuant to Delgado to those arms which the court has held are unprotected. Kessler intimates in dicta to automatic weapons, explosives, and chemical warfare weapons. The outer limits of that have not been tested, and because fully automatic weapons are banned in a manner of speaking federally, I would not expect that case to even come before the court.
But under your test, if those types of things are not protected by Article 1, Section 27, it's because they were not known at the time of the Constitution's drafting to be used for self-defense?
It would more so be because they were developed and used exclusively for the military. That's what Kessler says. We don't see that being the case for so-defined large capacity magazines. We don't see that for suppressors, to Chief Justice Flynn's question. We don't see that for semi-automatic firearms, which were specifically developed for civilian use. We don't see that in a lot of arms. So my tendency to say yes to your question, Justice Garrett, is because Kessler specifically calls them out in dicta as arms that were developed exclusively for military use.
So can I ask you about the permit issue? Are there aspects of the permit in which law enforcement has discretion to deny a permit? Or at least, is there an aspect in there where there's a need to be concerned about discretion?
So it's a shall issue permit, but it can be denied on reasonable grounds, and that is the review prescribed as well for the circuit court that reviews the denial should a review be sought. So I would say a reasonable ground standard, especially given the breadth of material that must be completed before seeking a permit to purchase, would certainly open it up to what I would characterize as subjective, almost entirely subjective when it comes to the area of presents a likelihood of mental illness. That, where's that line drawn? We have a lot of fun litigation with that when it comes to concealed handgun licenses, which case law describes as a privilege, not a right. Here we're dealing with the fundamental right to purchase a firearm.
Can I ask you a question about the standard on a facial challenge and the role that the factual findings that the trial court made play into that? Because the Court of Appeals said it's a facial challenge, so those factual findings don't matter. If you take issue with that, why?
Yes, Your Honor. So especially when it comes to the magazine issue, because what we're really getting into is the scope of arms to which Article 1, Section 20, to which Ballot Measure 114 applies. We're not dealing with a question of one arm, for instance. So one could have an arm that there's a manner of use, manner of possession placed on. For instance, one must have a safety. Is a safety an undue frustration or burden or infringement? And that's where we would actually get to that third phase of the analysis. This should have been stopped at the first phase of the analysis. But the factual findings really went to show the breadth of arms prohibited by Ballot Measure 114, show the level of infringement, the level of frustration placed on the arms. And so Christian specifically calls out the first step of the case is figure out what level of burden or infringement is imposed by the law. The trial court did that, and then the Court of Appeals reversed for essentially determining the arms to which this law applies. Defendants describe these arms as far less common than they are. Our expert testified that 90% of his inventory would likely be prohibited under Ballot Measure 114. That's a much larger infringement than how defendants describe it. The other issue is this is really unheard of in case law to have 2 courts agree that the arm is protected, but the second court determined that nevertheless, we're going to allow these arms to be banned. And so I don't think we need to reach the third step of the analysis. I think the third step of the analysis is a little hard to apply here because it shouldn't even get here. The 2 cases that apply it are Christian and Boyce. The Boyce case was a court of appeals, and there they were analyzing whether or not you could prohibit loaded arms carried in a loaded manner. And that's where undue burden, undue infringement on the self-defense aspect is more squarely addressed. Because this should have been stopped at the first prong of the analysis, it's kind of unnatural to reach the third phase. Kessler, Blocker, and Delgado did not.
You don't take any issue with the general standard that for a statute to be facially unconstitutional, it must be unconstitutional in all circumstances.
No, I do not take issue with
That's
that.
the standard. You just think that this law is unconstitutional in all circumstances.
And it certainly wasn't described to be constitutionally applied in any circumstance. So we're not seeing a circumstance like in Christian where the court said, well, you know, if you have that, yes, this is a burden on the manner of possession law is a burden on self-defense, but at the end of the day, you can go get a license for it. That's, again, it's kind of why it's weird to apply this third step to what Kessler, Blocker, and Delgado clearly say is an absolutely unconstitutional law.
So the trial court's determination that we're talking about protected arms, were there any disputed facts that entered into the court deciding it that way?
And certainly, I mean, defendants described the arms that were common in 1859 as nothing but single-shot muskets. We're seeing our expert addressed 600 years of firearm manufacturing history that showed a plethora of arms that were developed that could carry 10 rounds or more, up to 22, I believe was the highest I recall. But that's not even as big of an issue on the protected arms portion as it is to look at the Colt revolver, common 5 to 8 rounds, and extrapolate from there that the increase to 11 rounds is just an astronomical change. These aren't even remotely the same arm. At the end of the day, we still carry Colt revolvers. They're extremely common firearms. They're inferior to the more modern pistols. There's some folks who would disagree on that, but I will reserve the rest of my time for rebuttal.
And we'll give you your rebuttal, but yeah.
May it please the, excuse me, may it please the court, Robert Koch on behalf of the state. My plan this morning is to begin with the legal standard that governs challenges under Article 1, Section 27, because I think that's where so much of the dispute is between us and plaintiffs in this case. This court's case law, dating all the way back to Kessler, Delgado, Hirsch-Friend, Christian, lays out that Article 1, Section 27 allows the legislative power of the state to reasonably seek to promote public safety as long as does not unduly frustrate armed self-defense.
And oh, go ahead.
Go ahead, Justice.
That's the Christian test that the state relies on, or the articulation in Christian, right?
Yeah.
And plaintiffs are saying that that doesn't account for language in the cases you've just mentioned, which suggest, according to plaintiffs, that the state's authority to regulate is limited to the authority to regulate the manner of possession or the manner of use. How, given the language that the plaintiffs are relying on, is your test consistent with those cases?
So it's consistent with those cases. I'll respond to that in 2 ways. First, even if it does have to look through the lens of manner of possession or use, we think that Measure 114 satisfies that. But when you look back at the cases, they do talk about the fact that state legislative power can regulate possession and use, but it never talks about it as sort of the exclusive lens through which the state power can be used. And in fact, if you look at, starting with Kessler, they start to do a bit of the historical overview, but particularly in Hirsch-Friend, there's a very extensive historical deep dive that looks at the right to bear arms dating all the way back to England and the English Bill of Rights, and how our framers adopted the text of our Constitution, specifically from an Indiana provision, which had been interpreted by the Indiana Supreme Court by that point as recognizing that the legislature can reasonably seek to promote public safety. And so from our standpoint, that is the overall lens that this court's case law talks about the right. That's the legal principle, and that's sort of the legal framework
But was
for
the Court of
looking at the right.
Appeals, was the Court of Appeals decision in this case the first time that a court has held that something is a protected arm and still the legislature may completely prohibit its possession because it's a reasonable regulation? Has that ever happened before?
Not to my knowledge, and I don't think it actually happened here, Your Honor. I mean, so the court assumed it was protected without actually deciding the question, and then it just proceeded to say, well, even if it were, so there's, in the text of the opinion, and there's also a footnote that reiterates that we're not addressing this question.
Okay, but it's the same idea, right? It stands for the idea that the legislature's authority to reasonably regulate arms would extend to the ability to completely prohibit the possession of an arm for even by a person who's not a felon.
So I don't think the Court of Appeals precisely did that, and I think part of it is, and this is where it gets a little difficult, that they sort of bypassed the first question of whether it's a protected arm at all.
And I'm curious about that because the state has done that in its argument now, going directly to the standard. So I'm curious, is the state suggesting that we also assume for purposes of our review of this case that this is a protected arm? The state does not appear to be conceding that it is, but where is the state on that?
It's up to this court's discretion whether you want to address one or both questions. I think either avenue affirms the facial constitutionality of the large capacity magazine restrictions. And I think the difficulty here is it comes down to sort of how you're defining the arm. And so what the Court of Appeals did is sort of said, okay, well, we're just looking at firearms generally and magazines generally. And, you know, let's assume that those are protected arms. But the law here doesn't unduly, reasonably promotes public safety, doesn't unduly frustrate the right to armed self-defense because capacity compliant magazines are readily available, they're readily usable. But then and so that assumes that you're looking at the arm through the lens of like magazines or just firearms generally. Whereas, you know, what plaintiffs pointed out in their argument and what the law specifically does is it restricts large capacity magazines. And nothing like a large capacity magazine was common at the time of statehood. It was certainly not commonly used for self-defense. And our briefing,
Well, can I ask you about that? Because if I understand your brief, you acknowledge that weapons that range from 4 to 8 repeating shots were common for self-defense?
Yes, Your Honor.
And so your argument is premised on 11 being significantly different from 8?
Yes, and it's significantly different for it's significantly different for the technological reasons why that was not commonly used for self-defense. They didn't really exist at the time. And it's also significant because of the public safety risks that are posed by magazines of larger than 10 rounds.
So I think Mr. Aiello argued that magazines of 10 or greater were not unknown at the time. Whether they were common may be a different question, but if they were known, if they existed or their antecedents existed, is that a relevant factual dispute that we need to resolve? Because the Court of Appeals seems to have taken the approach that none of these facts mattered, because if it's a reasonable regulation for public safety reasons, that's enough. Can we get out of the case quite that easily, or do we need to look at the historical record about the degree to which these types of magazines may have been known to the drafters?
You can get out of the case that easily. The short answer, because if you're looking at it as sort of firearms and magazines generally, the restrictions here reasonably promote public safety without unduly frustrating armed self-defense. And so it meets that standard. We think that the large capacity magazine restrictions are facially constitutional for the separate reason that they're not protected arms. And to go back to the start of your question, sort of the historical, the antecedent type stuff, there were certainly attempts to make large capacity, well, actually detachable magazines didn't exist until the late 1800s. But at the time, there were attempts to make firearms that could fire more than 10 rounds without having to pause to reload. There were attempts to make that. But the technology didn't exist to make them functional or safe or practical to make on any scale. And so there's a lot of the testimony at trial that plaintiff's experts talked about, or plaintiff's expert, had to do with firearm manufacturers in Europe attempting to try to make large firearms. In the United States, there was not anything like a firearm that could fire more than 10 rounds without having to reload until, I believe it was the 1880s. It was the Henry and, I think it's the Winchester, or something. It's in our, we mentioned it in our brief. Those had to use a lever action. It was a lever action type firearm, which by the definition of Measure 114 would not constitute a large capacity magazine. And so there's not really any factual dispute on that. It's just the legal question or the legal significance of, okay, there were attempts to make these things. Does that confer constitutional protection?
Let's suppose that the drafters know that there are attempts to make these things. And so maybe we then can infer from the historical record that the drafters would have anticipated that with technological developments, these things might become prevalent and common within a few years. What's your best evidence and argument that with that understanding, the drafters wouldn't have wanted those developments to be available for self-defense purposes?
I point this court to Delgado and Kessler, but Delgado said this a little bit more explicitly, where the framers believe that their interpretation was that the framers were codifying a right to bear arms of what was commonly used for self-defense at the time of statehood. And so that raises the question of, is a large capacity magazine of the sort of what was, that of the sort is the specific specific language from Delgado. Is it of the sort of what was in common use for self-defense at the time of statehood? And the answer is no. And back to Justice Flynn's question about, well, does it really matter? Like, is there really a distinction between 6 to 8 rounds and more than 10? And the answer is yes. And the best example of that is Las Vegas, which was the
Well, but I
largest.
think at this point, we're at the threshold question, weapon-wise, not the public safety or anything like that. So weapon-wise, I mean, Delgado dismissed, there was a switchblade, so it had a spring, which court talked about, that was not present commonly at common law or, statehood. Why is the difference between the 8 repeating guns and an 11 repeating magazine on a gun now not just the technological advance like a spring in your knife?
Yeah, well, and to be honest, Your Honor, I was mentioning Las Vegas not as the public safety justification, but as emblematic of the completely different technology that current modern-day large capacity magazines pose compared to what existed at the time of statehood. So with let's take the 6 to 8 pepper box pistol which was commonly used for self-defense at the time of statehood. You had to manually put primer, propellant, and projectile into each barrel. You had to manually load that, shoot it, clean it, and then reload it again, all of which took minutes just to fire 6 to 8 rounds. Whereas modern-day large capacity magazines, their technology and functionality derive from 3 separate technological innovations from the late 1800s two of which were military, the detachable magazine and I believe the automatic fire. The way that the technology operates now allowed the Las Vegas shooter to fire more than 100 rounds in a minute. And you just contrast that to what was the rudimentary firearms at the time of statehood. They're completely different form, functionality, and lethality, which is why they are much more akin to the weapons of war that in Delgado, this court said does not get constitutional protection. But again, back to Justice Garrett's question, the court doesn't have to address that question. The Court of Appeals didn't do so, and I think that is certainly that is one way that this court can go, and it's really up to the court's discretion. We think the law is constitutional under both approaches.
Can I ask you a procedural question? So this case is before us on a facial challenge. The trial court chose not to address an as-applied challenge. So is that still out there, an as-applied challenge is available?
It's available. Plaintiffs didn't raise one. They expressly disavowed raising one, so it's not in this case.
What about a class action as-applied challenge? Would that be available?
I fear getting too far out over my skis, but I don't have a ready belief as to why one would not be.
So, okay, go ahead.
I will say, on that point, Your Honor, I just do want to note, the legislature recently passed a law over the summer, SB 243, that amended the statute to delay implementation of each piece until March 15th.
Can I ask you a question about the permit to purchase program, and in particular to follow up on the briefing by the Eastern Oregon counties and I guess the practical reality of how this would work? So there's the firearms safety course, and I think under the ballot measure that can be done online. But as a practical reality, how does the in-person demonstration work? And I guess, again, if you can comment on the amicus briefing by the counties.
Yeah, I thought that it's great that the counties submitted an amicus brief.
How does this work in Lake County, for example?
Excuse me, sorry?
Lake County, it's a big county, there's not many people. How would it work there? I mean, how does somebody do this in-person demonstration?
So the permit demonstration happens with a permit agent. So that would be any local police. The permit agents under the statute are the local police and the local sheriffs. And so each county has those. And in terms of the specifics around in-person demonstration, which would go toward the application of the statute, which isn't, in our view, in this case. But in terms of how that will happen, my understanding is that there were work groups around developing guidance standards from the state police. I don't know that those have happened. I'm not sure what stage those are in, is the short answer to your question. Largely because this law has never gone into effect and never came close to going into effect.
So following up on Judge Tukey's question, I have a number of questions for you about permit to purchase. So as I read the statute, and please actually correct me if I'm wrong, because I'm not sure if I'm reading it correctly.
Yep.
I understand that the police chief or county sheriff must engage in this inquiry about whether the applicant is qualified. Is that right?
I don't know, they determine whether the person's qualified.
Yeah, so they're required to sort of determine whether they're qualified.
Yes.
Okay. And one of the ways that they do that is, are they subject to various orders, et cetera? And then, so they make an inquiry about qualification based on, do they present a reasonable grounds that they are likely to be a danger to self or others, correct?
Yes.
Okay. And one of the things that they do to make that inquiry is they inquire about mental or psychological states as evidenced by past behavior or past statements, correct?
Yes.
And one of those is
I'm
a
sorry, I'm not seeing statement in the
threat
text of
of
the statute.
unlawful violence,
Okay.
all right? I'm curious because threat of unlawful violence, under our Article 1, Section 8 jurisprudence, under Robertson and Moyle, a mere threat of unlawful violence is protected speech, right? To get to an Article 1, Section 8 ability to sanction that, it needs to be a genuine threat of unlawful violence, and there has to be a presence of imminence and a reasonable likelihood to carry out, right?
Yeah.
So do I read this correctly that somebody can be deprived of an Article 1, Section 27 right based upon their exercise of an Article 1, Section 8 right?
No, because the law would have to be applied constitutionally. So if there was a deprivation, that if somebody was denied because of constitutionally protected activity, if that would be unconstitutional. And they could then, if that did happen, they could file an action in circuit court and challenge it on that basis. So
I mean, I would love it if the statute were written that way, but it doesn't appear to be written that way.
I think every statute must be applied constitutionally. And so our constitutional rights apply in the application of all laws.
Can I ask you another question? Is there any other example where a citizen of Oregon would need to take a class before they could exercise their constitutional right?
I don't know. And I don't know if I don't think of driving as a constitutional right. I assume it's not.
Not.
I think the answer to that is no, but I hesitate to say that definitively.
So Article 1, Section 27 talks not only about the possession of arms, but as we've heard, it also talks about self-defense, right? I have always, I guess, guessed that self-defense as a concept, as a legal concept, is constitutionally protected by Article 1, Section 27. Like, the legislature couldn't eliminate the defense of self-defense that might pose constitutional problems. Could the legislature say, you can't avail yourself of the defense of self-defense until you've first taken a class about self-defense? And until you've taken the class, you just have to stand there and take the beating?
No, and that's not the scenario we have here, because as this court has recognized in Kessler and Delgado, there were many arms used for self-defense at the time of statehood, including knives, billy clubs, things of the sort. And so even if someone doesn't have, even absent a firearm, people have other arms that they can use to defend themselves. And I do want to add that the historical deep dive done in Kessler, Delgado, Hirschfriend, and also, again, and reiterated in Christian, has recognized that throughout history, the right to bear arms, firearms themselves, do pose, they're rather unique in their lethality. And so there's always been a sort of, in the principle of armed self-defense, when we're talking about firearms, there is the sort of added public safety threat that legislatures have been free to regulate.
And as the rules have been implemented, I don't know this, the class that is contemplated, and I realize nothing has gone into effect yet, does the class cost money, or is it provided by the state?
The Oregon Sheriff's Association has an online class that is free to take. I believe you pay a small, maybe $50 to get a certificate.
Okay, but the class itself is
The class itself is free.
Okay, thank you.
So for the magazine limit, you would have us basically ultimately get to the unduly frustrate portion of the test. And that sounds like a legal standard, but it also sounds like something that would be dependent on some perhaps underlying factual determinations. Do you agree?
So I'm understanding the question. When we're talking about magazine restrictions,
And
we're
whether-
examining whether the right to bear arms is unduly frustrated, are there facts involved? I think it's ultimately a legal question with a legal conclusion. I do think facts in the world certainly can and frankly should inform a court's analysis of that question. And I guess that's where, the Court of Appeals looked just at the preamble of the law, I believe, and the specific provisions in the statute to sort of reason through whether the right is unduly frustrated. We do think that alone answers the inquiry, is sufficient to answer the inquiry. But we also cite to
Does the
publish.
preamble have the force of law? It's before the enacting clause, so it
Yeah,
doesn't,
my
does it?
understanding of that is it informs the text, a court's analysis of the text and context of a statute. And it also does it can serve as the sort of legislative history to sort of inform what voters were thinking when they enacted the statute.
Can I follow up on the Chief's question about unduly frustrate? As I understand the plaintiff's position, their position is if the law goes beyond regulating the manner of possession or the manner of use, then it unduly frustrates the right. Why is that wrong?
It's wrong because that's not the legal standard or the legal question.
What is the test for unduly frustrating, if that's not it? And where does it come from?
It comes from this court's case law, and the court has never delimited the outer bounds or frankly the specificity of what constitutes undue frustration. The only time that a court has struck down a law as unduly frustrating a right is the absolute prohibition on billy clubs and on flip knives. Sorry, I'm blanking on the specific name, but switchblade knife.
But we did so without analyzing that component, right?
Correct. It was just, it's an absolute ban, that's enough. And I think that's where, to dovetail back to Justice Flynn's question, I do think that the court's analysis can, and in this case should be informed by things such as published peer-reviewed epidemiological studies, which are cited to in the preamble, and which we submitted in the record, and which we cite to in our briefs, which show that specifically with magazine restrictions, given that the defining feature of a large capacity magazine is to fire it more than 10 rounds without having to pause to reload, their use in a mass shooting leads to more injuries, more deaths, more shots fired. States that have enacted large capacity magazine restrictions, when they have a mass shooting, when they have a mass shooting event, there's on average fewer shots fired, fewer people injured, fewer people killed. And then when you look at that, and then you look at the fact that capacity compliant magazines are readily available and readily usable, and in fact, when a firearm is used in self-defense, there's statistical data that we submitted in the record that was based in part on the NRA's own database of defensive gun uses. More than 10 rounds are virtually never, if ever, used in self-defense.
Is there a capacity floor beyond which the state could not regulate, in your view?
Yeah, I got it. So 6 to 8 would be really hard to justify.
Okay.
Because
And like the Barney Fife law, where it's just like one bullet preferably kept in your pocket or something like that, the state would agree that that would be too far?
I'm so sorry, I missed the first part
No,
of your
don't
question.
worry about it.
Sorry, I'm sorry, sorry.
So explain your answer there a little bit, because to me, the 6 to 8 sounds like it would go to whether these are protected weapons in the first instance historically. But as I understand your test, even if they're protected weapons, they can be completely banned if, for purposes of public safety, and it's not unduly frustrating the right to self-defense?
I think I think it would be a much closer question, in part because, well, we don't know, there's not a record, we have not looked at the ready availability of like something like a 2 or 3 round magazine particular. So how readily available, how readily usable they are, I don't know that information. I do know that there are, that all major gun manufacturers and a number of aftermarket gun manufacturers have made magazines of 10 or fewer rounds specifically to be compliant with existing state restrictions on magazine sizes, because I think we're up to around 13 to 15 states currently. So so to me, that's part of the sort of
Okay,
unduly
sure.
frustration analysis.
So did the trial court apply the unduly frustrate test? And if so, were there factual determinations that were essential to the court's conclusion?
The court did not conduct that analysis. The court sort of adopted its own legal standard of requiring intermediate scrutiny to assess the law, and the court undertook its own public safety analysis, thinking that mass shootings weren't severe enough. Like that.
So the court resolved it on the public safety component, is your understanding of the trial court?
The court made a number, the court sort of fashioned its own test of sort of closely examining the public safety justifications, and the court, as in doing that, interpreted the text of the statute to ban pretty much all firearms, because the court viewed it as banning all magazines. And
Wouldn't that be part of the unduly frustrate component?
it could be. So it's possible that that's the approach the court was taking. It sort of interpreted the statute to ban it. That is certainly one view of the trial court's findings. I think, but it seemed to also just impose a different legal standard as well, which we don't think is supported by case law. But certainly I think that part of the court's analysis before the trial court was its construal of the statute in a way that we view as atextual, that just can't be supported by the text of the statute.
All right, thank you.
Thanks for, we ask that the court affirm the decision of the Court of Appeals and reverse the trial court's judgments. Thank you.
Thank you. And rebuttal.
May it please the court. I have a couple just quick things. First, the trial court did conduct every phase of the analysis. That's clearly articulated in the trial court's opinion. The class is not free through the Oregon State Sheriff's Association. The Oregon State Sheriff's, you can take the class, but you need the certificate to get the permit. So I guess in theory, one who just wants to study firearm safety could take it for free, but in order to get the permit, you have to get the certificate. That class only covers 1/2 of the permit. Educational portions, you still have to have the in-person demonstration. The statute does not itself describe what the cost of that would be. To the extent it matters, I took one last Saturday and it was $200. Cars, Twitter, and blood alcohol tests also did not exist in 1859. The fact of the matter is the Constitution of Oregon and the United States applies to things that did not exist when the document was written. Delgado makes that very clear.
So when we look at modern technologies in this context and other contexts, as you note in your brief, we try and figure out what the underlying principles of the constitutional provision that we're applying are. In your view, what are the underlying principles? What were the goals or objectives of the people who drafted Article 1, Section 27?
To allow people, and Hirsch's friend delves into this as well, the ultimate goal of any right to bear arms is the ability to repel a tyrannical government. There's also state defense. There's also self-defense, defense of others, protection. Kessler goes into the exigencies of rural living, protecting your livestock and family from predators, be they wolves, bears, cougars, people. Those are all encompassed within the right to bear arms. And her friend specifically calls out the ability to repel foreign governments or to protect the citizens from a tyrannical government, which, going back to the text of Article 1, Section 27, is why state defense is very relevant. Arms of enemies are going to advance and change over time. Arms owned by the military are going to advance and change over time. Civilians need to have access to not necessarily the same arms, but an evolving level of arms, and that's specifically called out by Delgado. Delgado contemplates the change from a single action revolver to a double action revolver, which was a paradigm shifting development in firearm technology far and above the increase from 8 to 11 rounds.
I understood you to just say that one of the purposes is basically to protect against a tyrannical government and possibly invading foreign governments. So that sounds like there would be no restriction on military type uses under Article 1, Section 27. Is that ultimately your position?
So the case law disagrees with me, and I would say itself on this. Kessler kind of has some circular logic. Kessler says, because Oregonians had the same or even better firearms than the government did at the time of its founding, that means that the development, the improvement in firearm technology has now separated the two. That doesn't make sense. I would say it certainly extends to hand-carried personal defense weapons. Perhaps not aircraft carriers, perhaps not helicopters, perhaps there are exclusions, but certainly for an arm that a single person can carry by themselves and use to defend themselves, to defend their family, to defend their livestock, to defend the state.
Can you help us draw that line? Like if the principle is to fight off a foreign military, how do we draw the line for Article 1, Section 27 to be anything short of what a foreign military might have?
Where I would recommend the court draw the line is at hand-carried personal defense weapons. An Apache attack helicopter cannot be carried in one's hands. A tank cannot be carried in one's hands. That would be, if the court's going to draw a line, I would recommend drawing the line there. I think case law disagrees with me, frankly, on that point. Kessler in dicta says otherwise. But if the court were going to adopt a rule, hand-carried personal defense weapons would be a comfortable place to draw that line.
So if that were the test, and we talked about this earlier, but an automatic weapon, I think your test would allow for the possibility that that would be protected because it could be carried by hand.
Certainly. And there was arms approximating automatic weapons in 1859. They used superimposed loads. One trigger pull, multiple rounds would come out of it. It was rudimentary technology, but right now, as the case law stands, Delgado says of the sort in existence at 1859, but includes as modified by their modern improvements.
When we look at history, one way is to look at, well, here's the weapons that existed at the time. Could we also look at, well, here's what the founders would have thought could have been the consequences of allowing this right? And are those consequences different in terms of the damage that could be done with the weapons then than now? And so if the founders are like, we're okay with this type of consequence, why should we assume that they're okay with a much greater type of consequence now?
I think that would put the court in serious trouble with its existing precedent as far as free speech goes. Certainly the consequence of a tweet compared to a handwritten letter that was sent and directed to one person, or even the printing press. The amount of words that I can put onto Twitter compared to the amount of words that my ancestors could send pales in comparison. So I think looking at the effect would be an incorrect way to approach the question. The question is the intent. The founders wanted us under Article 1, Section 8 to be able to convey ideas, and that is what free speech does. the founders wanted us to be able, the drafters of Oregon's Constitution wanted us to be able to repel our government, to repel enemies. We certainly saw warring with Native American tribes and others in the founding era. That's what the founders wanted us to be able to do. And they wanted us to be able to do that with the best, at least hand-carried personal defense weapons that were available. Our expert, actually, I think both experts agreed that civilians in 1859 often had better arms than did the military, because the military was slow to adopt things like rifling, slow to adopt things like metallic cartridges, slow to adopt things like breech-loading weapons, because they wanted cheap, mass-producible arms, and the individuals were able to get into the nitty-gritty and get the best arms, which would then later be adopted by the military.
And can I ask you about the permit? Because as I understand it, you acknowledge that we've said certain people can be prohibited from carrying weapons. Is there some aspect of the permit that is that you would understand is permissible in order to make sure that somebody who doesn't qualify for the weapon doesn't get it?
At best, the background check would be acceptable. Again, I would say that falls outside of manner of use, manner of possession restrictions, but at best, the background check might be included within there. The problem there is we already have background checks at the point of sale. So really at this point, are we just stacking background checks on background checks to delay, which is the fundamental purpose of ballot measure 114. It says it in the preamble. It says it wants to reduce firearm sales. It says it wants to dissuade Oregonians from exercising their right to bear arms. It says that it's more dangerous if you own arms, so really you ought not. That's what the preamble's getting at. All citizens have the right to bear arms, except for those who have been denied that right through due process because they are felons, or because they've been adjudicated as incompetent, or because there was a process, for instance, ERPO's, extreme risk protection orders. Those are all judicial acts that deprive someone through due process of the right to bear arms. Ballot measure 114 doesn't provide that. Ballot measure 114 provides a prospective denial of rights.
Can I ask you about the groups you were talking about? There's certain groups. Your brief says it may be limited to people who've been convicted and possibly just felons based on Hirsch friends, because that's all we've had to address so far. When we take the historical perspective that you're urging, should we construe Article 1, Section 27 as not being violated if there's prohibitions on certain other groups that might not have had the same rights in 1857? So could, under Article 1, Section 27, there be prohibitions on other groups having weapons?
No, I do not think the court can interpret it that way in light of the 14th Amendment. Obviously,
Just what did the founders intend? Like, there might be a federal constitutional problem.
I think the founders of Oregon didn't intend for African Americans to live here. I don't know. I do not think that would be a fair way to interpret Article 1, Section 27. I think the fair way to interpret Article 1, Section 27, like the Second Amendment, is that even though there were certain people who were not regarded as equal citizens, what was intended for equal citizens and who now is an equal citizen? Obviously, African Americans are equal citizens in this state and in this country and should be regarded as such.
All right, thank you to both counsel. This case is submitted and we'll be in recess until 1:30.